Tom Jipping, welcome to Constituting America's Constitutional Chats. We'd love for you to just give us a brief overview of the topic today, and then we'll go to questions.
Sure. Well, thanks for having me back. This is a great organization. We were talking at our staff meeting this morning when I mentioned that I was going to be on the podcast, and a number of my colleagues have been here as well. Just what great fans we are at Heritage of all of the work that you're doing. So thanks for having me. This is a very important case. If you can, think of a constitutional issue where Governor Gavin Newsom, the city of San Francisco, the city of Los Angeles, and conservative states like Idaho or Oklahoma all agree. I can't think of one either. Well, they're all on the same side in this case. And it's a case that presents both issues regarding the kind of role that the courts play as opposed to legislatures, as well as how to go about interpreting the Constitution. As everybody knows, homelessness is a very serious problem all across the country, and especially out west, and especially in smaller cities like Grants Pass, Oregon. And the city council there passed ordinances, which exist in many cities, that prohibited camping in public spaces like parks and on sidewalks and so on. And of course, in the United States, political issues often become legal issues, so that got challenged in the courts. And the U.S. District Court in Oregon, and then the U.S. Court of Appeals for the Ninth Circuit. The Ninth Circuit is kind of the western third of the country. They said that prohibiting camping in public spaces actually violated the Constitution. The Eighth Amendment to the Constitution prohibits excessive fines and cruel and unusual punishment. And the Ninth Circuit, instead of focusing on what the punishment was, the Ninth Circuit shifted its focus and said that you can't impose punishments, whatever the punishment is, on this kind of conduct. And the Eighth Amendment simply doesn't say that. So suddenly there was this straitjacket put on local governments, no matter what their politics, Democrat, Republican, liberal, conservative, suddenly all kinds of options for trying to wrestle with this serious problem of not just homelessness, but the presence of homeless people and attendant problems in communities. Suddenly they found that all kinds of options had been taken off the table, and by a court no less. So the city of Grants Pass appealed that decision to the U.S. Supreme Court. The Supreme Court held arguments in that case in March, and with a case of this kind, and that was an argument kind of in the latter part of the term. Most people expect that the court will announce a decision sometime in June. The court schedules oral arguments, but they don't schedule announcements. So we have to roll the dice a little bit on that. But so they're in that decision stage right now. And the question is, does the Eighth Amendment prohibit imposing, in this case, civil or criminal sanctions on public encampments? And the lower court said yes. Grants Pass and many other cities. There are many briefs filed by outside organizations that aren't parties to the case, like Gavin Newsom in San Francisco and Los Angeles, all of whom are under this straitjacket. They've all argued no, the Constitution does not dictate how to address problems like this. The Eighth Amendment doesn't go that far. Instead, state and local governments have to wrestle with that, and the Constitution does not bind their hands. So that's the case. There's all kinds of big implications for it, and we'll get a decision in it probably in the next month or so. But it'll be significant for constitutional purposes, but also in more practical ways regarding problems that cities and counties across the country have to wrestle with.
Well, thank you. That was a great summary. And thank you for your kind words about Constituting America. We here at Constituting America are big fans of the Heritage Foundation. So thank you for all you do. And I know Janine has got some questions lined up, so I'm going to turn it to Janine.
Well, yes, thank you so much. I had a little bit of a difficult time hearing and understanding everything you were saying. So I want to just kind of recap, and I think it's really good to have a kind of an elementary summation for our young students that listen. So from what I think I understood that you said, it is illegal to can't. So I'm going to go like through 1 through 5, and you can check, come back and say you were correct on this or not correct on that, or that type of thing. So here's what I thought I heard you say. 1, it is illegal to camp or put pitch tents in a public space, but the city's hands are tied because number 3, the courts have come. One of the higher courts, the appellate courts or federal courts, has said in the Western Division, it is an unusual punishment to punish a homeless person for being in a tent in a public space. So can you just say yes or no if I surmise that correctly?
Most of it is correct. Grants Pass, Oregon passed ordinances, like a lot of other cities have, that prohibited camping, sleeping in public areas like parks, sidewalks, that type of thing. The United States Court of Appeals said that doing that was unconstitutional, that cities may not address homelessness in that way.
Okay, so let's stop right there. So the federal courts are saying they trump local courts because it's ruling on a constitutional Bill of Rights. But what I don't understand about that is it becomes this gray line, this gray area on the law. We're seeing other examples of this type of thing where, we don't want to prosecute because no one would believe that they were actually capable of answering the question. But it seems to me, if you say this person, you can't prosecute this person because they're homeless, can't you do that with anything? It's like, okay, well, so-and-so committed this crime. Oh, but it would be cruel and unusual punishment because they were just, their mother left them, or they were just having a bad day, or, where do you draw the line? It just seems like it's you know what? They went out and killed somebody, but you can't prosecute them because, nobody's going to believe anything they say. I think that there just seems to be this kind of malleability to the law lately. It's like, well, it's the law, but and I didn't know that decision was made. But so they harmed somebody, but they didn't get enough sleep the last night. I just don't really know where this stops. Because if a person went out and wanted to camp that had a lot of money, but they want to camp out on a public space, well, they wouldn't be allowed to do it. So I'm all for helping the homeless and gosh knows people that are having a difficult time, but it just doesn't seem like this kind of gray to a black and white law. I don't like the direction that our country's going with this. And I don't understand how a law is a law, but suddenly they're making excuses for it.
Well, this is where a little bit of civics comes in handy. As everybody watching the show, I'm sure knows, we have 3 branches of government. They're supposed to do different things. It's up to the legislative bodies, Congress, state legislature, local city council, to make laws. It's a hard job. They have to try to wrestle with problems like this. It's up to the courts to interpret the law like the Constitution. The Constitution is a rule book for government. Government has to do what they do, but they have to follow the Constitution when they do it. So if a law that a city council might pass, like we're talking about here, if it genuinely violates the Constitution, well, then it's got to go. But the question is, How,
But
how
it's who's making it. Sorry to interrupt, but who's
I'm,
making the
I'm
decision
getting
about
to,
whether it's cruel or not?
I'm
Yeah.
getting to that, yeah. And that's why it's so important to clarify what judges are supposed to do and what legislatures are supposed to do. Judges are supposed to interpret the Constitution. They're supposed to interpret statutes. What that means, we interpret written things all the time. When I drove to work this morning and I saw a speed limit sign, I read it and I determined what it meant. That's interpretation. Judges are not supposed to make things up. They're supposed to take the Constitution as it is and try to figure out what it already means. What do the words cruel and unusual punishment mean? And in this case, I think the lower courts went way beyond that. And they put aside what those words actually mean. What does the word punishment mean? Well, I got smacked by my mom when I was a kid and did something wrong. I know what a punishment is, and so does everybody else. Here, they said, no, the Constitution says you can't impose any punishment on certain kinds of behavior that we want to protect. And public camping by the homeless is one of them. Judges aren't supposed to do that. That's far beyond the role that judges are supposed to play. It's supposed to be legislatures that make those judgments. And that's why clarifying what the different branches of government, this just basic idea of civics, is so important because it helps sort all of this out as to who's supposed to do what. Here, the city of Grants Pass, their city council should have the authority to try to wrestle with this problem. Judges aren't supposed to step in with their own ideas and say, no, you got to do it the way we want you.
So it'll be really interesting to see what the Supreme Court says. Because there's a flip side of this. It's maybe, there are two other ways to look at this, and I'll pass to Tova. One is perhaps not everyone who's homeless is on drugs. So I'm not saying that I'm not saying this in a stereotypical way. But let's just say the people that are homeless are addicted to heroin. Is it not cruel and unusual punishment to not get them into a rehab and help them? Instead of letting them continue to stick a needle in their arm and be heroin addicts. I mean, that's the whole point. I mean, I think that a law is a law is a law, and when someone's interpreting it, we can interpret it another way. I think it's cruel and unusual punishment to let someone stay and continue to pick themselves up with drugs on the street. Not to mention, what about the danger it poses to the people? The people that are just trying to live there are potentially walking through the park. So you have people that want to be able to walk through the park safely. They can't do it. So it just seems bizarre to me that the interpretation doesn't really even seem to take all the other elements of the citizens that are just trying to use the park. They have a right to use the park, and now they can't get into the park. But what about that heroin addict who actually really needs help? And it's cruel and unusual punishment to let them be able to, sit there and continue to suit up.
Well, letting them do that is not a punishment, which means that's my point. The Eighth Amendment.
But if I may interrupt you for a second, I do think that is a punishment because I think
not in the Constitution sense. It's not the Eighth Amendment.
Well, but what I'm trying to say is it is a cruelty to continue to give someone the opportunity to destroy themselves and shoot themselves up in a public park where a needle might be there that an ordinary citizen might walk through and step on.
Yes, and the question there is, who is responsible for considering the cruelty of that and how to address it? My point is that it's legislative bodies like the city council, not judicial bodies like the courts.
Yeah, well, it's going to be interesting to see what happens. What do you think the leaning of the Supreme? Have they heard it yet? Have they heard the case yet?
They've heard arguments. I have a very difficult time believing that certainly a majority is not going to reverse this decision. As I said at the top, when you have Gavin Newsom and the city of San Francisco agreeing with conservative states like Oklahoma and Texas, something's up. And I don't think that a majority of this Supreme Court is going to allow judges this much room to just think of what they want to have happen and make everybody toe the line. Judges don't have that much power, and I think the Supreme Court's going to say so.
Interesting. And then what will happen with that? Then cities will be free to say no more encampments on sidewalks and public parks. So if the cities choose to do that.
Yes, cities will have the authority that they had before, about a year ago when the court stepped in. It doesn't mean they're going to do it that way. And these are complex problems that require a lot of creative thinking. But the point is, the Constitution does not decide those issues. And since it doesn't, the people we elect, like city councils and state legislatures, it's their responsibility.
Yeah, it'd be interesting to see. All right. Thank you so much. Sorry there was a little crosstalk there. It's hard to hear. But thank you so much. And I'm going to toss to Topher. Thank you.
Hi, thank you so much for being on and for your time. I was curious about taking a bit of a step back and talking about kind of what governs the rule of public spaces and how that differs from private property. So kind of like what's considered a public space, what rules generally govern those, and how that might be different from private property, and kind of how we're seeing that play out in this court case.
Sure. Well, there's a constitutional right to private property in the U.S. Constitution that's mentioned in the Fifth Amendment. But public spaces are typically defined in statutes or ordinances. So the government defines, which areas, whether it's a sidewalk or a park or a government building, it defines what those public spaces are. There's usually not much disagreement as to what the public space is. It's usually, well, what can be done in that public space? And there, the emphasis is on the word public. So I don't have the same rights to do or to say whatever I want in the way that I do on my own private property. There's more of a balancing that goes on, and the discussion with Janine, reflected that in the sense that with public spaces, the public has to have access and a reasonable opportunity to enjoy, what's public. And so you can't allow really serious disruptions of that in the way that the kind of encampments and other sorts of obstructions that we're talking about here can do. So balancing that's not easy, no doubt. And when you do have kind of nagging serious problems like we do have in cities particularly, that can be a challenge. All the more reason for courts not to unnecessarily step in and kind of bind the hands of our public or our elected officials who have to wrestle with these things.
You mentioned that there's kind of like a interesting ideological alliance in this case in particular. So I'm curious what parties tend to be on either side of this debate? Like what are the parties who are arguing in favor of upholding the court's decision to, define removing encampments as cruel and unusual punishment? And then what are kind of the people on the other side of the issue?
That's an excellent question. One of the places I go to sort of get a sense of that, there's a blog called SCOTUS blog, SCOTUS blog, which is a great resource for cases before the Supreme Court. And they link to the different briefs that are filed in any particular case. So if you run down the list of what we call amicus briefs, those are, amicus curiae is a Latin phrase that means friend of the court. So you have parties, groups that are not actually involved in the case, but they're interested in it and they have something to express. They can file briefs too. And if you run down that list, that's where you see these strange bedfellows, so to speak, who are arm in arm. Whether a city is run by liberal Democrats, like let's say a San Francisco or a Los Angeles, or conservative Republicans, they have to wrestle with the same issues. They may wrestle with them differently. They may have different ideas about how to approach it. But they all want the same flexibility and the same freedom to make the kinds of policy judgments that it's their job to make. So there's your common interest, you know, none of them want a Supreme Court to step in or a lower court to step in unless it's absolutely necessary. But if the Constitution doesn't say anything about it, courts shouldn't say anything about it. They shouldn't step in and get in the way. So there's your common interest, liberal, conservative, Democrat, Republican. And that's one reason why I think the Supreme Court, you know, who knows? We may have a unanimous decision with the conservatives and liberals on the Supreme Court taking the same position.
Interesting. And could you talk more about who is in favor, like on the other side? Is it
Well, I think
like
there,
what groups?
yeah, there you'd have, I suppose maybe your homeless advocates, your service delivery, you know, nonprofit type organizations that that especially focus on the homeless community. So there, from their perspective, it's look, there's the problem, and you know the homeless are they're camping on the sidewalk because they don't have any choice. You know, they don't have any other place to go. The city doesn't provide for, you know, more shelters and this kind of stuff. So I think it would be advocacy groups that have a particular and a strong focus on the population that we're talking about here. You know, they're not probably not a huge constituency, but they're very vocal and they have a unique perspective on the problem. So I think that's where you probably find the strongest advocates for the court stepping in and drawing a line.
Interesting. And oh, were you going to say something?
No, just great. That was a great question.
Oh, thank you.
It's
Yeah,
not,
it's such a
it's not just the hair splitting legal arguments themselves, but when you do take that step back, that gives you a different perspective.
it's interesting because yeah, I mean this case isn't even about dictating policy. It's just expanding the range of policies. Like it's not saying that mayors have to remove homeless people from an encampment. It's just saying that they aren't banned from it. So I think that's an interesting
No,
aspect of the case.
But it is saying the lower courts did say here that mayors may not prohibit sleeping on public property. That the
Yeah,
Constitution
exactly.
takes that option off the table. And so there's your legal question. Does the Constitution, which only talks about punishments, take off the table the option of city councils and mayors to prohibit camping in public?
Right. No, it's just interesting the framing of enforcement of law with punishment. Like it's interesting. Because yeah, it's just an interesting question. Like for instance, like arresting someone is not the same as like imposing a punishment necessarily. Like in the US legal system, there's quite a delay actually between simply removing someone from the act that is outlawed versus then imposing a punishment. So has that distinction been made within this case? Like has it been argued that clearing out homeless people from an area is not the same as like imposing a punishment because like is the punishment defined as something that is imposed after deliberation and like a verdict is
Not in
imposed?
this case. I mean, the difference we're talking about here is what conduct should be punished versus what punishment should be imposed for that conduct. The Eighth Amendment to the Constitution has something to say about the second, about the punishment, but the Eighth Amendment doesn't have anything to say about conduct that ought to be punished or that ought to be prohibited. That's up to the legislative branch. That's what we've been talking about here. It's who's responsible for what. Society makes judgments about that kind of thing all the time in many different ways about what sort of conduct should be required or should be prohibited. I mentioned the speed limit, you know, coming to work this morning. Well, take that as an example. You have the issue of should the speed limit on Interstate 66 be 55 or should they raise it to 65? And then there's the question of, well, if you exceed the speed limit, should the fine be $100 or $500? Those are two different questions, and the Constitution only has to do with one.
That makes sense. And then I'm curious when the courts are ruling on this and they're looking at precedent, are there any comparable cases in the past that either side is drawing on to make their argument?
Well, the Ninth Circuit, the Court of Appeals, they said that they had a precedent because that court previously in 2018 had said that there's a right to sleep in public when you're involuntarily homeless. Now, again, that right's not in the Constitution. The court made it up. But then when this court in this case is dealing with this, they're looking at that precedent from their own court. There aren't really direct precedents from the Supreme Court on this question, which is why several other circuits, not the Ninth, which did what we've been talking about here, but several other circuits reached the opposite conclusion on that question. So there isn't specific precedents from the Supreme Court on it, although there are precedents that help to define how far judges can go when they interpret the Constitution. Does a court have authority to say, well, it says the word punishment, but I want to talk about, the conduct that's being punished instead. I want to talk about what the Constitution doesn't address. Well, the Supreme Court's going to say, no, you can't do that. You don't have that kind of authority. So I think that's where the Supreme Court's precedents will come in. But yeah, there's a lot of wiggle room in precedents, as I'm sure you know. One person's precedent is another's irrelevant case, and that's what lawyers are trained to do, is to take advantage of the ones that help you and to push aside the ones that don't.
Well, my time is up, but thank you so much for answering all these questions, and it'll be really fascinating to see what the ruling on this is. So thank you for providing that context. And now I'll pass on to Jordan.
Growing up, I know that parks have signs on them that say open dawn till dusk. I was a big park kid. I've been kicked out of a lot of parks at nighttime when I was trying to play. So my first real question is, why is there a difference between homeless and not homeless? How can there be a difference in the how can they say there's a difference in the Constitution between homeless and those with a home for being in a public area?
Well, if I understand your question, they're really not saying that the Constitution makes this distinction between homeless and not homeless. They're saying that the Constitution doesn't allow prohibiting anyone from either sleeping in a public place or doing other things that the ordinances in Grants Pass prohibited. You don't see the word homeless in those ordinances. Now, the vast majority of people who would fit that description would probably be homeless, but it's an objective focus on the conduct. For whatever reason, should we allow anyone to camp in public spaces that are supposed to be available and accessible to the public? As part of their approach to dealing with the homeless, the city council there in Grants Pass said no. And they should be able to make that decision. The kind of distinctions and considerations you were referring to, whether it's Philadelphia or any other town or city, the people who are elected to run those jurisdictions, they should have the freedom to consider those things, to investigate whether the problem they're facing is one of, involuntary circumstances or choices, all the different varieties of circumstances. They should have the most freedom to come to those judgments, wrestle with the kind of problem they have in front of them, and try to do something about it. The whole point here in this case is that the courts should not, especially when the Constitution says nothing about it, the courts shouldn't step in and say, no, we're going to put handcuffs on you. We're going to take options off the table. We're going to prevent you from even considering approaches to this problem that we don't particularly like. If the Constitution says so, fine. Government's supposed to follow the Constitution. But if the Constitution doesn't, judges aren't supposed to pretend that it does. And so homelessness in Philadelphia might be a different kind of a problem than homelessness in San Francisco. And the officials who run those two cities ought to have the maximum flexibility to be able to address that. That's why, as we observed before, Republicans, Democrats, liberals, conservatives, all over the country have the same interest in doing that, and that's why they're on the same side in this case.
Has there been any discussion about places that do have homeless shelters? Like by me, there is a rescue mission, and it is not full. Is there any discussion about almost forcing, I guess is the best word, almost forcing homeless into these shelters? Since it is not, since forcing them out of the public space would be unnecessary punishment, but it would be forcing them into a better situation. Has there been any discussion of that?
There's a few wrinkles in that would no doubt end up in court too. If it's, for example, if it's a religious organization, which I mentioned the Central Union Mission here in Washington, D.C., which it is, the government cannot require people to participate in a religious organization. So there's that sort of wrinkle going on there. There's unfortunately there's a lot of places where there simply aren't enough shelter spaces and other sorts of reasonable alternatives to sleeping on the street. What's supposed to happen there if those that alternative just simply doesn't exist. In this case, there was an emphasis on people being involuntarily homeless. That is, they didn't have any other place to go. That's a serious problem, and it's more or less of a problem in different places. I think that's why many city councils and so on would focus not so much on forcing you to do something as focusing on what you may not do. In other words, taking the public interest into consideration, we simply can't have people camping out in public spaces, including sidewalks. One of the ordinances in this case prohibited people from basically camping in the approach to people's driveways, which is, connected to private property as well. Prohibiting that kind of conduct, and then it's a more open question as to what people would choose to do then. But I do think, just a personal opinion, I do think one of the things city councils ought to pay perhaps more attention to, rather than some of the sort of politically correct nonsense that takes up a lot of their time. Take a candid look at what are their policies with regard to providing alternatives to the street for the homeless. And that includes opportunities for religious organizations to step in. Instead, we have we're in a culture today which has such an anti-religious bias that you have city councils forcing religious, whether it's Catholic charities or other groups, they're saying you may not provide services because you don't have the right politics or something like that. Well, that harms everybody. So I think city councils ought to wrestle with that, providing alternatives to the street, even while they're saying public interest really means that we can't have people camping in public places.
And then my last question is about really turning a blind eye to breaking the law. So we have many laws that I believe kind of led us to this situation. The clearest example I can give is really marijuana use in illegal states. There are many times where officers are almost forced to turn a blind eye, or you'd be arresting somebody very often. I'm in Pennsylvania. It's not legal, but you can walk around and you'll smell it, and it's easy to find where it's coming from. and then there's nothing being done about that. So with that example, you can make that for so many different infractions that we've turned a blind eye, and it's kind of been a trickle down effect of this same of getting here. We got to this point making this case a year ago, but that wasn't the first time that there was homeless camps. I've had a homeless camp under the bridge near my house for 15 years. So what was going on all of that time?
That's an interesting observation. We had several years ago when I came to the Heritage Foundation, we had a project that was trying to, with federal law, the United States Code, trying to get a grip on how many hundreds and thousands of provisions imposed criminal penalties for all sorts of just ordinary behavior. There's thousands and thousands of them. And it kind of exposed what you're talking about, because the one side of the coin is imposing, criminal penalties for behavior that shouldn't be criminal, versus you can have behavior that's criminal, but then the government doesn't enforce the law. I think if you simplified that kind of a picture, it would be easier to focus on what the real problems are. And maybe this is an area where that could benefit from that. I don't know. But I think our elected officials, and I worked in the United States Senate for 15 years. I saw this stuff up front, and it's not any prettier close up. Politicians like to evade responsibility for what they're supposed to do. They'd rather have the courts do it. They'd rather have the bureaucrats do it. Anybody so that they don't have to take responsibility for it. I think we should try to work it the other direction. We should try to make sure, and this is one reason why courts should butt out of areas where they don't have authority to be involved, because our elected officials need to do their job. We need to know what they're doing and whether they're doing their job. And I think simplifying things would really help to clarify that.
All right, thank you. It's time to pass to Kathy for some audience questions.
Well, thank you, Jorn and Tova and Janine. And first, we want to recognize our students and teachers that are with us today. And we have D'Angela Hines with Emerald Coast Christian Academy. So D'Angela, welcome, and welcome to your students. And if we have other teachers and students that are watching today, let us know in the Q&A, and we'll be sure and give you a shout out before the end of the program. We also want to thank radio station KKVV in Las Vegas, 1060 on the AM radio dial. KKVV airs these programs Monday evenings at 6 p.m. Pacific. So thank you to all our listeners in Las Vegas. So, Tom, Andrew K. starts with a question just about the Eighth Amendment in general. Do we have any clear insight into what the founders who wrote the Eighth Amendment meant when they used the term cruel or unusual punishment?
We actually do. One of my favorite legal historians, he was a longtime professor at Harvard. He actually wasn't a law professor. He wasn't a lawyer. He was a historian. Raoul Berger was his name. He wrote a book on what cruel and unusual punishment meant to the founders. And, cruel, they understood to be unnecessarily savage in sort of the intentional infliction of pain. Unusual meant not in common use, something that was out of the ordinary type of thing. It's that idea that punishment is punishment. We know that that's the sanction that's imposed, whether it's jail time or something else. So we do, by zeroing in on the language that they used, and our goal is to try to find out what did they mean by what they put in the Constitution. I think we do have a pretty good idea. The question today for the Supreme Court is more whether that's what they think they should stick with, or whether they are just kind of tired of what the framers meant and they want to make up something new. That's the question of whether the judiciary has the authority to do that. So I think we do have a pretty good idea, even more so with the Eighth Amendment than some other constitutional provisions. And so we've got to really renew the commitment to say the Constitution is what the people established, and it's supposed to remain the same until they change it. Judges don't have the authority to make stuff up, to just, they prefer a different constitution, so they'll just invent one. They don't have the authority to do that.
Well, thank you. And then Tracy asks, why do you think the Supreme Court agreed to hear this case?
Well, I mentioned that the Ninth Circuit, which is the court that decided this case, interpreted the Eighth Amendment in this really aggressively kind of activist way, and that other circuits, in particular the 11th Circuit, in a different case, took the more traditional approach and decided the issue in another way. So when you have what we sometimes call a circuit split, different circuits decide the same issue opposite ways, that's the most common reason why the Supreme Court takes a case in order to resolve that conflict. And especially when it involves, as this case does, an important constitutional issue. The decision, even in the Ninth Circuit, was very, very close. After in a court of appeals, first decision is by a group of 3 judges. And if you lose there, you can ask the whole circuit. In the case of the Ninth Circuit, there's 29 judges on the Ninth Circuit. You can ask that the whole bunch of them, redo the case. Well, when that happened, it was 14-13 to decide the case the way they did. I mean, that is as close as it gets. This was a very controversial decision. And so, but yeah, the circuit split, big constitutional question. That usually sets up a likelihood that the Supreme Court will consider it.
Well, thank you. And then we have another one of our listeners asks, will this case impact the encampments and punishments and arrests from recent college demonstrations?
No. Again, these are the encampments that are at issue in the Grants Pass case. That's governed by specific ordinances that the city council passed that govern public places. Those ordinances cover what they do. The protests and disruptions and encampments we've seen on college campuses, some of which are private, those have to do, in addition, with school policies, and in particular the use of properties. There's a common issue in the sense that should a group, whether it's protesters or the homeless, have the right to just dominate areas of in our sort of broadly public spaces that the public ought to have access to. But these are different, I think, 2 different sets of laws or regulations that govern the 2 situations.
Okay. And then we'll type this into the Q&A. Lacey can probably type it if you'll just state it one more time. Lizette Flores asks if you could repeat the name of the Harvard professor that was just mentioned, and then the name of his book.
The professor's name is Raoul, Raoul Berger. And I'm trying to think of the specific title. I think if you Googled Raoul Berger and Cruel and Unusual Punishment, I think you'd easily find his book on that. He has several books looking at the original understanding of different provisions of the Constitution. One of the strongest advocates for courts using that approach. And he was a liberal Democrat. He wasn't a conservative Republican. I mean, this notion that the judges have a defined job description that they ought to stick to is not a liberal or conservative idea. He's one of the most prolific. He was publishing big law journal articles into his 90s. Amazing man. And I think we could all benefit from his wisdom.
Well, interesting. Well, we will look that up and get that to Lizette. And then Mark DeRoba asks a fairly broad question, but I think really important. How does the federal government enforce rules that are in direct conflict with state governments? Or
Well-
what happens when a federal government's,
Sure. Well, the
I mean-
10th Amendment says that the federal government has delegated powers, that is, powers that are specifically given by the Constitution to the federal government, and states have reserved powers, which is all the rest. Okay. The Constitution also says in Article 6 that we call it the Supremacy Clause, that federal law trumps state law, but only when there's a direct conflict between the two. And that's the rub, is when is there a conflict that is so kind of irreconcilable, where the immovable object meets the irresistible force, And in that case, if there is a direct conflict, we call this preemption, the federal law does trump. There's a lot of places, a lot of areas where federal and state law might be similar or might cover some similar ground, but can coexist and don't cause conflicts. But where they do, the federal government wins, and that sometimes takes a lawsuit in a court, picking the winner. But that's under the Constitution. They have delegated and reserved powers, but federal law, when there's a conflict, takes precedent.
Okay. And then Julianne Smith asks, if SCOTUS rules in favor of the cities, what kind of changes do you envision them making? Do you think cities have been hanging back a little bit, kind of waiting to see what happens in the Supreme Court? Do you think cities will get a little bit more aggressive in some of the actions that they're taking, or what kind of changes do you think we'll see?
Well, with the Supreme Court, there's what they decide, but also how they decide it. That is, they could rule for the city of Grants Pass, but do so in probably half a dozen different ways. Some of which might give the cities and local governments, just complete freedom to do what they want to do. Or they might say, well, you have a little bit more room and here's a new set of restrictions or whatever. So it kind of depends on the details of how the Supreme Court rules. But in general, these are problems that cities have dealt with for a long, long time. And this is such an unusual interpretation of the Eighth Amendment that, and this is why liberal and conservative jurisdictions are all on the same side on this. They know what's at stake, and I'm sure they're kind of chomping at the bit to say, get the Supreme Court out of our way and let us get back to the tough job of trying to tackle these serious problems. So, since the Ninth Circuit's decision last year on this, and it didn't apply nationwide, it only applied in the Ninth Circuit, but the Ninth Circuit is the largest one, and it was kind of a signal to the rest of the country. I'm sure lots and lots of local governments kind of took a pause and said, let's watch and see what this case happens, because if they rule against Grants Pass, we won't be able to enforce our ordinances either. But if they do, then we can resume and go with that. So everybody knows what's at stake in this case, and local governments especially have the most at stake. And that's why I think, lawyers that are employed by cities and towns, I'm sure have been busy over these months trying to game out, well, if this happens, then what do we do? If this happens, then what do we do? And they'll be ready to take a course of action when the Supreme Court decides, which is going to be probably in the next 4 to 6 weeks.
Well, thank you. And speaking of states and local governments and various solutions that they have, Charlotte Chips offers up one and says that Florida will fine Daytona Beach if they don't remove the homeless in a specific area. They must provide services instead. And I just didn't know if you might have a comment on that, or any other innovative solutions that you've seen or heard about across.
This is a very big country, and it's a very diverse country. You might have the same general problem, but it takes many, many different forms. And this is why, as we've discussed, judges shouldn't step in and dictate to our local officials what their options are. The Constitution doesn't do that, and therefore judges have no authority to do that. And folks in, addressing that in Daytona Beach are going to have a very different kind of a problem on their hands than in Boise, Idaho. So we need to get judges out of the way, get their personal opinions out of politics so that our elected officials can have maximum opportunity to address the problems that we face.
Well, thank you. And that's a great note to end on. And we're right at the top of the hour. And Tom, we just appreciate so much you being with us today and all the great work that the Heritage Foundation does. So
Well, thanks for having me.
thank you. And we thank our audience for all your great questions. And we hope that you'll join us next week, Tuesday at 2 p.m. Eastern. We're going to be talking about gerrymandering. We've never discussed that topic on any of our constitutional chats before. We're going to talk about how these congressional district lines are decided, how they're drawn, how often they're drawn, and a case that's also before the Supreme Court that has to do with that. So we hope you'll tune in.